Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to take a closer look at the new bipartisan bill pending in Congress that could make federal data privacy law a reality. Now, earlier this month, the Senate and the House of Representatives released a draft of the American Data Privacy and Protection Act, or ADPPA. This bill would provide a national framework for privacy to supplement and, in some cases, replace the patchwork of state and industry specific privacy regulations on the books currently. However, the bill has two major obstacles to overcome. One is the extent to which it will preempt existing state laws, and the other is whether to allow aggrieved consumers to file suit, known as a private right of action. Many Capitol Hill insiders are skeptical about the bill's prospects, but congressional Democrats may be ready to deal, cognizant of the fact that they may lose control of the House in November, meaning that there's no time like the present to reach an agreement with the Senate leadership. So, what's in the bill? Well, companies would essentially be required to limit their data collection to the minimum necessary for them to operate. With rare exception, businesses could not charge fees to users for accessing their own data, and minors would be protected from targeted advertisements. The current draft establishes the right of users to have their own data corrected or even deleted. The Federal Trade Commission would be responsible for enforcement of the ADPPA. They would also be charged with maintaining a registry of data brokers and overseeing the opt-out compliance by companies under their jurisdiction. The bill is chock full of provisions that echo Europe's GDPR, as well as the California Consumer Protection Act. Companies, as well as nonprofits, would have affirmative obligations to obtain informed consent to the use of consumer data, and these disclosures must be made in plain English. Organizations would be expected to maintain minimum data protection and information security standards, although for financial institutions, compliance with Gramm-Leach-Bliley would satisfy this requirement. Even subbing out these responsibilities would not get organizations off the hook, because they would be expected to exercise due diligence around vendor management. So what does this mean for our viewers? Well, the pundits are still doubtful that this bill will pass, but it makes sense to take a look at its requirements, particularly around the data protection and information security controls. Even if this bill doesn't become law, many of these requirements are already in place at the state or industry level, and they are precisely the types of protocols your underwriters are looking for as well. Now, Alliant is not a law firm and we don't dispense legal advice, but we do maintain relationships with some of the top privacy attorneys in the country. So if you need a referral to one, please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com, and I'll be happy to put you in touch with several qualified firms whom you can vet for yourself. Second, and I know I sound like a broken record on this, not all insurance policies are created equal. You'll want to make sure that yours provides regulatory coverage for the full range of data privacy violations that could result in a proceeding, not just those arising out of a data breach. And coverage for fines and penalties needs to apply the law of the relevant jurisdiction most favorable to the insured on the question of insurability of such damages. Now, please note, this is intended as general information and guidance, and you'll want to consult with a qualified insurance broker about your specific coverage needs. Here at Alliant, we stay on top of legal and regulatory developments because we are committed to helping our clients find the more rewarding way to manage risk. Thanks for watching.